How would your discoveries be protected in the absence of capitalism? This week, in the second edition of Questions for Anti-Capitalists, I will be telling you about, and don't change the video when you hear what's next, patents and intellectual rights. Before I get started on this, I want to make a short side note regarding anarcho-capitalists. Every anarcho-capitalist I've heard talk about this subject said that intellectual property is akin to a scam created and enforced by the state, which makes it less capitalistic. I'll give them this. The enforcement by the state parts, by all accounts, seems to be legitimate. Therefore, if an ANCAP sees this video, maybe I'll also get that perspective into why intellectual property rights and patents shouldn't exist. So, what are intellectual rights? In short, they represent the concept that if you create a new, unique idea or invention, you have influence over people who want to use and produce it through copyright. If you invent something and you're not under an agreement with the company to give up your copyright, then any one person or group who uses your idea will have to give you recognition, and a fraction of the profits they make by producing the patented item belongs to you. I know some of the people watching this have their own issues with copyright. In the past few years, legislation around it has been getting stricter, and to assure these people that I'm aware of the limits that should apply to copyright, I will start with them. This being said, how can the system of receiving a cut of the profits earned by using your patent be abused? I will give you the following examples. Let's say someone produces a song, an idea, or a brand. Now you use that copyrighted material on your own projects. Later on, either the owner of the copyrighted content or a corporation/legal team comes and takes all of the earnings you made from whatever you did that featured their content. In a society that doesn't revolve around putting first the interests of the corporations, the earlier situation is the copyright owner or its associates overstepping their boundaries. If someone uses a brand or logo during a campaign raising awareness for something, or makes a video using music or movie segments to emphasize a point or as a background, the point of the campaign or video wasn't the logo, the movie clips, or the music used, even if they supported the point being made. That is especially obvious if the feature content can be replaced with one that will still result in the same point being made. In this case, there should be regulations in place describing what percentage can be claimed by the copyright holders. For example, in the video, 20% of the earnings that result from that video will be split between copyright claimers. But for those interested, this can be discussed on a future date. If you, watching right now, have some experience with copyright law, or if you followed copyright cases, feel free to comment below any similar examples that you know of. Earlier I told you how claiming full rights over transformative content isn't an acceptable way to use copyright law. My second example is much shorter, and it will also be easy to grasp. Let's say that a person, or even better, groups of people around the world use as medicine a pill. They have its recipe, they produce and consume it when needed. Now a new producer enters the market, but this one also applied for a patent for that exact pill, which was already in the market. Now everyone who makes that pill would have to enter in agreement with the copyright holder. I hope it's obvious what went wrong here. Copyright shouldn't be claimed over an already existing product or idea. Now it's time to talk about how patents are intended to work. Looking back on the basic description of a patent, we see that it requires a contribution to human knowledge, that it's something new, an innovation. This means that we shouldn't expect patents to be filed by unexperienced people. Exceptions exist, but normally you would need a few years or decades of experience before you find a breakthrough. Making patents, it's a long-term goal. They allow people with some experience in the field to exercise their creativity. At the same time, they increase the sources of revenue of their discoverers. For the innovators who like or are very good at this type of discoveries, it allows them to apply their knowledge in personal contributions to the field instead of searching for corporate projects. That doesn't mean you can find sponsorships for a project that you get shared copyright from. Of course you can. This would be the main role of the patent and copyright system. I probably exaggerated the overlap between these two, but if anyone knows how, I can't wait to find out what improvements there are to this concept. If the subject comes up again when I will understand it better, I'll be more than eager to share it with my audience in a better form. Before closing this chapter, however, I want to bring to your attentions how having a system of intellectual rights in place can help progress in general. If people have extra incentives to innovate, you increase the chance of these innovations happening. Of course. And there's a long time between paradigm shifts. While in this long time, there's a lot of time for many innovations. If just 10% of them are caused by people motivated by searching for patents, that is a significant improvement to the world. Think for example of steampunk universes. Those are timelines which, after diverging from our own, developed many devices and styles that no one in our time did, because they were obsolete, but for them, it served a purpose. And yes, even obsolete discoveries can be useful today. They can show clearer picture of the time period from which they came, and be educational materials. Think of Da Vinci's inventions, which he never made, but which have been reconstructed by engineering teams to test how feasible they are. These were my thoughts on the issue of patents and intellectual rights. Have a great week, and let my channel make you stronger.